Hi everyone. Our presentation will be covering patent law in the medical device industry. Patent law is, generally speaking, intended to encourage innovation and competition by giving inventors temporary and exclusive rights to their designs. In the medical device industry, patent law, and more specifically cases involving patent infringement, have become increasingly important and represent a significant expense to these large medical device companies. The three types of patents are utility patents, plant patents, and design patents. A utility patent is the most common and covers things such as mechanical inventions and improvements. Design patents cover the new and original way something looks. These patents that don't have to do with the function of something, but more its overall design. Finally, the plant patents. These patents involve protection of newly created plants such as flowers, fruits, shrubs, and even vines. In order for something to be patentable, it must be new, non-obvious, and useful. The three different types of patent infringement are direct, induced, and contributory infringement. First, direct infringement occurs when someone attempts to make, use, sell, or import something that is patented. Second, induced infringement occurs when someone contributes to someone else's infringing on a patent. Examples of this induced infringement include things like selling patented parts of instructions on a patented process. Finally, contributory infringement involves two parties essentially showing intent to infringe, which comes at a higher level of guilt, and this is similar to induced infringement. The three main defenses to patent infringement cases are proving the patent is invalid, unenforceable, or not infringed on. The first, proving the patent is invalid, you can prove anticipation, whether it's already been made, the obviousness, if it's obvious to someone who has an ordinary skill level in that art, or enablement, if the invention is essentially not described well enough. The patent could also be unenforceable if the applicant intentionally withheld information when applying for the patent, or it could also be unenforceable if the infringer is misled into thinking the patent owner will not enforce the patent. The patent could also be not infringed on if the infringer has not actually infringed on the patent in question. The first case we're going to discuss is Synthes versus GM Dos Reis Jr. For the purposes of this case, we'll call them GM Reis. They're both medical device companies, the latter being a Brazilian manufacturer of medical devices. In this case, it has to do with patent infringement, and more specifically, the issue of personal jurisdiction when you have two companies from different countries. Synthes manufactures orthopedic devices, mainly orthopedic trauma devices like locking bone plates, and that is specifically the product in question here. And at a trade show in 2007, Synthes displayed one of these locking bone plates, while at the same time the Brazilian company GM Reis displayed what appeared to be an identical locking bone plate, allegedly infringing on multiple Synthes patents for the device and the design. So Synthes filed suit claiming that GM Reis was hurting their business in the United States and had made attempts to sell the device in the United States during and around the time of this trade show in 2007, and this occurred in San Diego, California. And GM Reis motioned to dismiss the case because they claim they were not or should not be subject to personal jurisdiction because they did not, in fact, make any attempts to sell the device in the United States. GM Reis' motion to dismiss was subsequently granted, and the case was dismissed for lack of personal jurisdiction. So while this case was dismissed, the actions of the business managers, specifically the defendant business managers, introduced multiple ethical questions. So first, if it was determined that GM Reis cannot be subject to personal jurisdiction, was it ethical for them to be displaying a patent infringing product at the large trade show in the United States? And while allegedly not attempting to sell this infringing device to U.S. customers, GM Reus may have been also marketing the device to the same foreign physician conference attendees, essentially the same international customers to whom Synthes was marketing their original patented device. GM Reus may have also demonstrated some ethical misconduct in the discovery phase of this case, potentially avoiding what Synthes contends would have been a significant deposition from one of the key GM Reus leaders, Mr. Lickenberry. Synthes believed that he would ultimately, or this deposition would ultimately produce evidence that proved GM Reus was communicating with potential customers in the United States during and around the time of that trade show in 2007. So after analysis of this case, it's evident that business managers at GM Reus clearly demonstrated an underdeveloped personal ethical standard. This apparent ethical myopia or lack of ability to identify an unethical situation ultimately contributed to their desire to display a controversial and patent infringing product at such an important international trade show, albeit in the United States. The next case we're going to discuss is that between Dr. Jan K. Voda and Cordis Corporation. This case involves an individual inventor, Dr. Voda, matched up against a large medical device company who were what he was suing for patent infringement. This case began when Dr. Voda filed a lawsuit against Cordis Corporation for allegedly infringing on some of his patents for his angioplasty guide catheters. And the case in 2006, Dr. Voda was granted royalties of 7.5% of the defendant Cordis Corporation's gross sales on the infringing catheters. At the same time, however, Dr. Voda, he was denied injunctive relief, so Cordis Corporation could keep selling as much as they want. Cordis was also found to have willfully infringed on these patents. So after this, Cordis Corporation appealed, and this judgment was ultimately upheld in terms of the 7.5% royalties paid to Dr. Voda. In addition, some new evidence was discovered that supported the plaintiff's motion for enhanced damages. This new evidence was not disclosed in the original discovery. So the judgment reflects a consistent pattern of court orders in favor of Dr. Voda, the individual inventor and patent owner. This concept of willful infringement, it seems to be unethical in its very nature, because to willfully infringe on a patent, you must act in a, quote, deliberate disregard for the property rights of the patentee. So in other words, you really need to be aware of the existence of a patent and continue to produce a product with substantially similar design and function, or you may actually utilize the patent for designing components or even the entire infringing product. This case also alludes to the potential unethical pursuit of short-term profit maximization by Cordis Corporation. The next case we're going to be discussing is Dr. Peter Rentrop versus the Spectranetics Corporation in 2007, which is another case involving a physician or an individual inventor suing a large medical device company for patent infringement. Essentially, in the 1990s, Dr. Rentrop used one of Spectranetics' new excimer laser catheters. Essentially, this laser technology was designed to ablate plaque in coronary arteries. And Dr. Rentrop, he's a smart guy. He was a very experienced cardiovascular interventionalist, and he suggested to some of the R&D guys at Spectranetics some ways to improve the device. And they took that seriously and started working on the device and working on it with Dr. Rentrop and improving it to his liking and his standard. Throughout their relationship, they failed to agree to compensation terms. Essentially, there was never anything written down that would either give Rentrop some type of royalties or ownership of the patent or any formal compensation agreement. And after failing to come to this agreement, Dr. Renschrop took the design and patented it himself. And so then, with this patent, he was able to turn around and sue Spectranetics Corporation for infringing on his patent. So the court ruled in favor of Dr. Renschrop due to this lack of formalized relationship between the parties. And so this really proves that if you're a large company and you're working with an individual inventor, you need to clearly define that relationship and what that compensation agreement is going to entail, because Dr. Renschrop, he was the one with the design. While he didn't invent the original product, he was the one that invented the design, or ultimately the final product that they would be selling internationally. The last case we're going to be discussing is Stryker versus Zimmer. Stryker Corporation is a large medical device company. They make all different types of tools that assist medical procedures. Stryker alleged that Zimmer infringed on 3 of its patents involving a pulse lavage irrigation system. And Zimmer claims that Stryker knew of the infringement since the year 2000, when 2 interns at Stryker and a first-year lab tech had the opportunity to examine the device. Zimmer, who was ultimately found to have willingly infringed on this patent, definitely has some obvious lapses in ethical decision-making. By the time this went to trial, Zimmer used a number of defenses to discredit the lawsuit, but the way they tried to prove that 2 interns at Stryker were responsible for identifying patent infringement seems to be very unethical. Comparing these cases discussed, we see that 2 cases involving patent infringement between individual inventors and large medical device companies are good examples of the powers of patents, and they're examples of the court ruling in favor of the individual inventors. In both of these cases, Renschrop v. Spectranetics and Voda v. the Cordis Corporation, the large device company was found to have infringed on at least certain claims of each inventor's patents. Comparing Synthes versus GM Reus to Renschrop versus Spectranetics and Voda versus Cordis, we see an interesting element of personal jurisdiction, where the first case, Synthes versus GM Reus, was dismissed because of a lack of personal jurisdiction. However, there were a significant number of ethical issues raised in the case. In looking at the effect of patent litigation on business managers and some alternative dispute resolution techniques, obviously the best way to reduce the cost of patent litigation is to avoid litigation altogether. And for many in the healthcare industry, alternative dispute resolution is easier said than done, especially in cases with millions of dollars in revenue on the line, and each party in belief that they have sufficient evidence to prove the wrongdoings of the other. To avoid the action, in a lot of these cases, including Synthes versus GM Reus, these companies, they could have gone to mediation or arbitration and attempted to come to some sort of an agreement outside of court. So after analyzing these patent infringement cases involving large medical device companies and at times individual inventors or patent owners, we determined that many of these cases could have been avoided if business managers had made more ethical decisions, and what we saw were the upstream marketing and really the R&D phases of new product development. And looking forward, we would anticipate a consistent increase in patent infringement cases, definitely not a decrease, as long as patent owners continue to see the value in well-designed patents and large device companies have the money to burn in patent litigation and continue to accept this patent litigation as just another kind of just another expense or cost of doing business. We should continue to see consistent patent litigation suits in the medical device industry.